The Supreme Court upheld expedited removals of illegal aliens without hearing 7-2 in 2020. But is it a suitable mechanism for mass deportations? Hello, this is Robert Romano, Executive Director with Americans for Limited Government and Americans for Limited Government Foundation. Hit that subscribe button. Today, we're going to be talking about federal courts reviewing, once again, President Trump's deportation programs that have included invocations of the Alien Enemy Act. It has also included expedited removals. It's had removals without hearings. And so the question is, does every single person who's getting deported, are they entitled to a Fifth Amendment due process hearing? And is that what Congress intended? We've in the past, we've looked at the 1996 Illegal Immigrant Reform Act that was passed by Congress, signed into law by then President Bill Clinton. And we've noted that there are lots of expedited removals under that law that occur every single year, more than 20,000. But when you look at the terms and conditions, it appears to be applying to arriving aliens. So if it's only for arriving aliens, well, what about aliens who have been here for much, much longer? And so, and in a previous video, we were also looking at provisions of the Patriot Act that allow for 6-month rolling detentions of aliens who have been deemed to be terrorists. It also provides for removal proceedings for those so-called terrorist aliens. And it's the Attorney General who will have a lot of discretion that Congress has provided to make that designation. And that under the Patriot Act, those persons would be given removal proceedings as well. And so we have expedited removals for arriving aliens under the 1996 Act. You have the 2001 Patriot Act that provides for removal proceedings or 6-month rolling detentions. And then finally, this seems to be maybe why President Trump has settled on using the 1798 Alien Enemy Act, which appears to apply in the case of a proclaimed invasion. And so you have the invading force. Do you have to have a judicial proceeding for the invading force? So designated. In this case, President Trump has said that Venezuela and Aragua are the invading forces. So if you were a illegal alien who came from Venezuela, you might be a part of that invading force. Do you get judicial proceedings in that case? That seems to be where Trump wants this to be litigated, because on the other laws, it might not go the way he's hoping. And then finally, is there a suitable basis either in the Alien Enemy Act, the 1996 expedited removals, the 2001 Patriot Act, for mass deportations? We're seeing polling from CNN that 56% of Americans want to see all illegal aliens deported. And that could be like 15 million people. That's going to be quite an undertaking, and it might not be able to do that. The government might not be able to do that if every single one of them is going to have a trial. So you have 15 million trials. Would you get that done in 4 years? I don't think. Maybe at best you could do 300, 400,000 such removal proceedings a year. I think that might be the record, maybe 400 to 500,000. That could be the record, but probably not too much more than that. Usually over 8-year periods, maybe. I think the record is 3 million removals all told by a president in modern history, with the amount of immigration judges that there are and so forth. But first, I wanted you to hear from Stephen Miller. He is the Deputy Chief of Staff at the White House, and he's going to talk about the kind of the dilemma that the government faces when it comes to the sheer amount of illegal aliens that have come into the country, and how do you deal with them in an expeditious manner. Take a listen to this.
Entire neighborhoods where you have to live in fear because of individuals here illegally engaged in extortion and crime. Not to mention the fentanyl. You have cartels that have functional control over the entire northern territory in Mexico who are pumping fentanyl, lacing our drugs with this chemical. Children are ending up dead. They're going out to a weekend party. They think they're taking something safe, and they get a heart attack and they die by the thousands. So we're not going to apologize for doing something about that. And I just wish we lived in a country where the media gave to 1/10 a damn as much about Americans who were murdered and brutalized and savagely killed, beaten to death, as they did about whether illegal aliens that we all agree are illegal aliens should get a million days in court and a million trials and a million this and a million that. There's 15 million illegal aliens that violently enter the country. If every one of them got the trial that you're asking for, it would take us centuries to remove them. Centuries. We'd be talking about this in 300-400 years. Their great-great-great-grandchildren would be the ones representing them in court. That's how long it would take. Illegal aliens who come to our country have to be removed, and they have to be removed quickly. And that is an essential component of having something that we like to call a country.
Stephen, on the
one
matter
last question.
of visa restrictions.
So that was the end of the questioning that Stephen Miller says it could take 300, 400 years if you're going to try to do 15 million trials for the removals. And so in the previous stream, but I wanted to lead with this, we've looked at Department of Homeland Security, the Thuraissigiam in 2020. This was under the 1996 Illegal Immigrant Reform Act, and it upheld expedited removals under the Illegal Immigrant Reform Act. And we were looking at the TRAC, it's a clearinghouse, the reports that show the amount of expedited removals that you see every single year under the 1996 law that Congress passed and that Bill Clinton signed into law. In the past decade, you're seeing about more than 20,000 expedited removals without any hearing whatsoever. 23,957 in 2014, 25,967 in 2015, 30,346 in 2016, 32,941 in 2017, 30,988 in 2018, 30,852 in 2019, 21,578 in 2020, 23,262 in 2021, 21,978 in 2022, 21,519 in 2023, 21,998 in 2024. Again, all without judicial hearings, but these appear to be arriving aliens. And so that might have been I think certainly is the intent behind the 1996 law, was to deal with inadmissible aliens, people you can turn back at the border. Now, some of these will, if there's a credible fear declaration, they request asylum, can you deal with them summarily without a hearing? And I think that's the purpose of this ruling. So we're going to jump into this. The U.S. Supreme Court upheld by a 7-2 majority expedited removals of illegal aliens without a hearing under the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. In the case, Department of Homeland Security v. Thuraissigiam in 2020. Writing for the majority, Samuel Alito noted that the entire intent of the legislation was to expedite removals. So we'll jump in here. Every year, hundreds of thousands of aliens are apprehended at or near the border attempting to enter this country illegally. Many ask for asylum, claiming that they would be persecuted if returned to their home countries. Some of these claims are valid, and by granting asylum, the United States lives up to its ideals and its treaty obligations. Most asylum claims, however, ultimately fail, and some are fraudulent. In 1996, when Congress enacted the Illegal Immigration Reform and Immigrant Responsibility Act, it crafted a system for weeding out patently meritless claims and expeditiously removing the aliens making such claims from the country. It was Congress's judgment that detaining all asylum seekers until the full-blown removal process is completed would place an unacceptable burden on our immigration system, and that releasing them would present an undue risk that they would fail to appear for removal proceedings. And so this case, it dealt with whether Congress was suspending habeas corpus with these expedited removal procedures. And the court found 7-2 that no, it had not. And that was with, Ruth Bader Ginsburg and Justice Breyer both voting with the majority. So it was a pretty clean-cut decision. But again, it was for arriving aliens, and it's based on the text of the 1996 statute by Congress. And so we're going to be looking at that, the 8 U.S. Code Section 1225, inspection by immigration officers, expedited removables of inadmissible arriving aliens. So arriving, I think that's a key consideration there. So are the expedited removals in this 2020 case that deals with the 1996 Act, are the expedited removals a suitable mechanism for mass deportation? Again, about 56% of Americans are saying they want to see all illegal aliens removed, but Stephen Miller says that if you try to do that, it could take decades, hundreds of years perhaps, to have all of the removal proceedings. And so you could be dealing with people's children and grandchildren. They'll be the ones who are appearing at the removal proceeding. I think he was exaggerating slightly there, but it's not too far off. It could take quite a long time. So, and Congress has dealt with this in the past by passing the 1996 legislation. So could they expand on that? Maybe that's another possibility that we should be looking at. Now, every year, I had just noted, there are over 20,000 such expedited removals, according to U.S. Customs and Border Protection data compiled by the Transactional Records Access Clearinghouse of such inadmissibles without any hearing as Congress provided. Again, more than 20,000 a year. And on due process, the court ruled it did not apply to aliens without longstanding connections in the United States. Alito wrote. So we can look at the court considered habeas corpus. Was Congress suspending that with the immediate expedited removals? And the other question was, were the plaintiffs' due process rights being denied? And the answer was no. While aliens who have established connections in this country have due process rights in deportation proceedings, the court long ago held that Congress is entitled to set the conditions for an alien's lawful entry into this country, and that as a result, an alien at the threshold of initial entry cannot claim any greater rights under the due process clause. Again, this is for arriving aliens. That's what the 1996 expedited removals entails. So is this a mechanism that could be used for mass deportations for people who have long since entered the country illegally? But do those people get hearings? And should everyone get a hearing? Should all 15 million illegal aliens get a hearing? That's what we're going to ask. At the time, nobody could have fully anticipated, except perhaps for President Donald Trump, that when former President Joe Biden took office, he would open the floodgates for illegal aliens with a record 10.8 million border encounters of illegal aliens from 2021 to 2024, according to data compiled by the Office of Immigration Statistics. And you can look this up, CBP encounters. This will show you everything for the last 10 years. And you see that during Joe Biden's tenure, 1.9 million in 2021, 2.7 million in 2022, 3.2 million in 2023, 2.9 million in 2024. These were far and away records. We'd never seen this many illegal immigrants coming to the United States. And Joe Biden largely released most of the people who came, close to 11 million under his watch, on purpose, we argue. So if there was ever a case for expedited removals as Congress intended, it is now. Now, speaking to reporters on April 14th, I just played the video for you. White House Deputy Chief of Staff Stephen Miller outlined the dilemma facing the American people, that there is simply not enough time to conduct the number of removal hearings that would be needed if everyone who Biden and other administrations let in gets a hearing. He quote, "There are 15 million illegal aliens that violated the country. If every one of them got the trial you're asking for, it would take us centuries to remove them." Centuries. We're talking about this in 300, 400 years. Their great, great, great grandchildren would be the ones representing them in court. That's how long it would take. Illegal aliens who come to our country have to be removed, and they have to be removed quickly. And that is an essential component of having something that we like to call a country. And I agree with Stephen Miller. This is clearly something that could be beyond the scopes of the capacity of the courts to handle. This problem that has been created by just having open borders and letting this, what Trump is calling an invasion, occur. I think that you have to consider, does Congress have the ability to deal with this problem? in a manner that could result in expeditious or expedited removals, or what Trump is saying is going to be mass deportation. It's what he campaigned on. It's what 56% of Americans want to see. Fortunately, in 1996, Congress acted, and Miller noted that also the Attorney General can act. The Attorney General has authority to overrule the Immigration Court, and that's actually by statute. And we've looked at this before as well. This has to do with precedent decisions, except as board decisions may be modified and overruled by the board or the Attorney General. Decisions of the board and decisions of the Attorney General shall be binding on all officers and employees of the Department of Homeland Security or immigration judges in the administration of the immigration laws of the United States. So the Attorney General can overrule the court, and this is under CFR section 103. Part 103, subpart A, section 103.10. And these are precedent decisions. And this is based in part on, we had looked at this before as well, under 8 U.S. Code, section 1103, powers of the Attorney General, determination and ruling by the Attorney General with respect to all questions of law shall be controlling. And then when you jump down to subsection G, the Attorney General shall have such authorities and functions under this chapter and all other laws relating to the immigration and naturalization of aliens as were exercised by the Executive Office of Immigration Review or by the Attorney General with respect to the Executive Office of Immigration Review on the date of the enactment, and that the Attorney General shall establish such regulations, prescribe such forms of bond, reports, entries, and other papers, issue such instructions, review such administrative determinations in immigration proceedings, delegate such authority, and perform such other acts as the Attorney General determines to be necessary for carrying out this action. And we also looked at, 8 U.S. Code, section 1182. This is about inadmissible aliens. And so, but the laws that Congress has enacted go far beyond what we just saw in 8 U.S. Code, section 1103. Under 1182 AA, aliens inadmissible on security and related grounds are barred from entering the country without any hearing, including, quote, and again, this is 8 U.S. Code 1182. And I'll read it from the piece so it's a little more organized here. Any alien who has who a consular officer or the Attorney General knows or has a reasonable ground to believe seeks to enter the United States to engage solely, principally, and incidentally in any activity to violate any law of the United States relating to espionage or sabotage, or to violate or evade any law prohibiting the export from the United States of goods, technology, or sensitive information, any other unlawful activity, or any activity, a purpose of which is the opposition to or the control of or overthrow of the government of the United States by force, violence, or other unlawful means, is inadmissible. Or any aliens the Attorney General finds to be terrorists. Quote, any alien who has engaged in a terrorist activity, a consular officer, the Attorney General, or the Secretary of Homeland Security knows or has reasonable ground to believe is engaged in or is likely to engage after entering in the United States in any terrorist activity, or has under circumstances indicating the intention to cause death or seriously bodily harm, incited terrorist activity, is a representative of a terrorist organization or of political, social, or other group that endorses or espouses terrorist activity, endorses or espouses terrorist activity, or persuades others to endorse or espouse terrorist activity or support a terrorist organization, has received military type training from or on behalf of any organization that at the time of training was received was a terrorist organization, or is the spouse or child of an alien who is inadmissible under the subparagraph if the activity causing the alien to be found inadmissible occurred in the last 5 years, is inadmissible. So the Attorney General can say an alien is a terrorist. Oh, you're on the terrorist watch list. You're inadmissible. And that's just the way it goes. That's what the laws Congress has passed to say, okay, we need to have better intelligence after 9/11. So we're going to have this in place. But the laws actually, that's a removal proceeding though. We'll get to 8 U.S. Code 1226A. But the laws I just cited, actually 1182, included terrorists. The 2001 Patriot Act expanded the types of terrorists that could be included. But the initial inclusion of terrorists in 1182 was actually in a 1990 Immigration Reform Act. And then the expedited removals was in the 1996 Illegal Immigration Reform Act. Now, on January 20th, his very first day in office for a second term, President Trump declared Tren de Aragua, MS-13, and other criminal gangs and drug cartels as terrorist organizations by an executive order in accordance with 8 U.S. Code Section 1189. Here it is, designating cartels and other organizations as foreign terrorist organizations, especially designated global terrorists. And so these criminal drug cartel gangs have been designated as foreign terrorists, and clearly the president has the power to do that and to direct the Secretary of State to go ahead and say, okay, these groups are foreign terrorists. And under the 1996 immigration reform legislation, under 8 U.S. Code Section 1225C, it authorizes that inadmissible aliens, especially those so designated as terrorists or national security dangers, can be immediately removed without a hearing. So then we get to the expedited removals, again, for arriving aliens. So we jump down to subsection C. Let's see here. Here we go. Removal of aliens inadmissible on security and health-related grounds. If an immigration officer or an immigration judge suspects an arriving alien may be inadmissible under the security grounds, the officer or judge shall order the alien be removed, subject to review, report the order of removal to the Attorney General, and not conduct any further inquiry or hearing until ordered by the Attorney General. And then the Attorney General shall review orders under the subparagraph if the Attorney General is satisfied on the basis of confidential information that the alien is inadmissible under security grounds, national security, or terrorism, and after consulting with appropriate security agencies of the United States government, concludes that disclosure of the information would be prejudicial to the public interest, safety, or security, the Attorney General may order the alien removed without further inquiry or hearing by an immigration judge. So clearly, you can do expedited removals of terrorists and other national security dangers, but the section of law that we're looking at under the 1996 is clearly for arriving aliens. So what about the ones who have been here for years and years? Is this something you can use for the expedited removals for mass deportation? I think it's a really, really good question. In short, when the Attorney General determines an alien is inadmissible under security-related grounds, they can be removed without hearing under the law Congress enacted that the Supreme Court upheld. While Congress did not stipulate how long the terrorists needed to have snuck in around in the United States illegally in order to be subjected to an expedited removal, the provisions of the law speak of, quote, arriving aliens, as it was in the Thuraissigiam case in 2020. That said, if the Attorney General has intelligence that the alien is a terrorist, and again, after consulting with the appropriate security agencies of the government, concludes that disclosure of the information would be prejudicial to the public interest, safety, or security, close quote, then the alien can, quote, be removed without further inquiry or hearing, as Congress's intent was that the government be able to perform the removal confidentially and expeditiously. Now, similarly, under the Patriot Act, under 8 U.S. Code Section 1226A, aliens who have long since arrived and are declared to be terrorists can either be detained on a 6-month rolling basis or removed via proceedings. And so this was another avenue. Can this be used for mass deportations? It seems that it would include judicial proceedings of some variety. When you have detention of terrorist aliens, the Attorney General shall take into custody any alien who's certified to be a terrorist. And there's a certification clause. The Attorney General may certify an alien if they, under security grounds, they're terrorists, or there's national security grounds, or is engaged in any activity that endangers national security of the United States. And then you have a limitation on indefinite detention. An alien detained solely under subparagraph 1 who is not removed under the title and whose removal is unlikely in the reasonably foreseeable future may be detained for additional periods of up to 6 months, only if the release of the alien would threaten the national security of the United States or the safety of the community or any person. And so you have to remove them, basically. The Attorney General shall place an alien detained under paragraph 1 into removal proceedings. And so that implies back to hearings here. Or shall charge the alien with a criminal offense not later than 7 days after the commencement of such detention. If the requirement of the preceding sentence is not satisfied, then the Attorney General shall release the alien. So if you declare an alien to be a terrorist under the Patriot Act, you either have to charge them with a crime or put them into removal proceedings. And then in either instance, you can have them indefinitely detained on 6-month rolling basis. And that too is subject to review. So with all of those proceedings, that doesn't seem to, allow for the, a mass deportation of 15 million illegal aliens. So maybe running out of options here. In short, Congress created a bona fide political question as it related to terrorist aliens, giving broad authority for the Attorney General to designate them so. But in the case of the Patriot Act, Congress's intention was that such an alien deemed a terrorist would be taken out of the country via removal proceedings. So we're back to hearings. This might explain why President Donald Trump resorted to using the 1798 Alien Enemy Act in his March 15 proclamation. Invocation of the Alien Enemies Act regarding the invasion of the United States by Transactional. Okay, so then we go back here. Under which 50 U.S. Code Section 21 provides for removals of invaders so declared who are not naturalized to be removed. Quote, whenever there is a declared war between the United States and any foreign government, or an invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government, and the president makes public proclamation of the event, all natives, citizens, denizens, or subjects of the hostile nation or government being of the age of 14 years and upward, who shall be within the United States and not actually naturalized, shall be liable to be apprehended, restrained, secured, and removed as alien enemies. Okay. And while 50 U.S. Code Section 23 provides for judicial review, that only appears to apply to, quote, alien enemy residents. So we jump over there. After any such proclamation has been made, the several courts of the United States having criminal jurisdiction and the several justices and judges of the courts of the United States are authorized, and it shall be their duty upon complaint against an alien enemy resident and at large within such jurisdiction or district to the danger of the public peace or safety, and contrary to the tenor or intent of such proclamation or other regulations which the president may have established, to cause such alien to be duly apprehended and conveyed before such court, judge, or justice, and after a full examination and hearing of such complaint and sufficient cause appearing, to order such alien to be removed out of the territory of the United States. So clearly you can have a resident removed, see someone who's here legally. So for example, if a citizen of Venezuela, that's the country that's named in President Trump's invocation of the Alien Enemy Act, is in the U.S. legally with a green card, they can be subjected to removal proceedings because they are, quote, residents under 50 U.S. Code Section 23. But if they are a part of the invading force and, quote, not actually naturalized, 50 U.S. Code Section 21 appears to apply. And so I hypothetically look at what if you have an invading army and they take occupation of territory in the United States? Hypothetically, if an invading force occupied sections of U.S. territory, they would not become residents subjected to judicial proceedings. Instead, they might be attacked by the U.S. Army to start shooting missiles at them where the enemy position is, and you're not going to have judicial proceedings. And so you would deprive them of their lives without due process. Clearly, President Trump would prefer to deal with the problem on military terms in this context, not to start shooting missiles at people, but to do the deportations and removals under the context of invading aliens. Because then is that a mechanism for mass deportation? Certainly, he's deployed the military to the border. He's declared a national emergency. He's declared at least Trinidad to be enemy aliens. And he's also declared Trinidad, MS-13, and other criminal drug cartel gangs to be terrorist organizations. Some questions emerge. Did Congress intend to replace the Alien Enemy Act when it adopted the 1996 Illegal Immigration Reform and Immigrant Responsibility Act? Or did it mean to replace the Alien Enemy Act when it did the 2001 Patriot Act? Now, I know neither law made provision for a proclamation by the president that there is an invasion or predatory incursion to be interdicted, as the president has declared. So maybe these laws do not overturn the 1798 Alien Enemy Act. If not, then is the Alien Enemy Act a suitable mechanism for the president to utilize for mass deportations? In the meantime, as federal courts consider these questions actively, more consideration might be given by Congress itself to settle some of these questions. For example, in the upcoming budget, as it provides for border security and immigration reforms, Congress might wish to expand the basis for expedited removals. As Alito noted in 2020, quote, Congress is entitled to set the conditions for an alien's lawful entry into this country. And so with millions of illegal aliens and an overwhelmed system, Congress might need to act to settle these questions, or the courts may end up settling it themselves. But even then, if Congress were to act, the Supreme Court might ultimately overturn further acts of Congress and simply confer, quote, residency on all illegal immigrants who have managed to evade authorities long enough as a constitutional matter and confer due process. So again, you go back to the Alito decision. This is a 7-2 Supreme Court decision. And it states that if someone's been here for a long enough period of time, let's see, due process. Here it is. The respondent's due process argument doing. While aliens who have established connection in this country have due process rights in deportation proceedings. So read it again. Aliens who have established connections in this country have due process rights in deportation proceedings. So does that mean that any attempt at expedited removals for someone who's managed to evade authorities for years and years, they had a notice to appear or something, and then they just evaded that? Does that mean they get residency? Does that mean they get due process? Does that mean mass deportation is impossible? Is that what Alito is saying here? It could be. If so, the illegal aliens might be here to stay permanently, which might have been the intention of Biden and other derelict presidents who refused to enforce the law all along. This is Robert Romano, Executive Director with Americans for Limited Government and Americans for Limited Government Foundation. Hit that subscribe button, ring the bell for notifications, and have a good day. But first, go to the chat here. Maybe you're upset now because it's like, oh no, if the court finds that mass deportations are unconstitutional, how can we deal with this problem? It's a really good question. It's because then Congress can't even deal with it. The president can't deal with it. 56% of Americans who want to see all illegal immigrants deported might have to depend on immigration judges. So you might need to hire more immigration judges after all. Now, President Trump proved that you can enforce the border without an act of Congress. You can seal the border without an act of Congress. He's reduced illegal immigration into the country in his first 2 months in office by more than 94%, which is barely 11,000 border encounters occurring in each of the first 2 months. And maybe that number can go down even further. But I think that President Trump's been very successful and didn't need Congress to act in order to secure the border. But he might need Congress to act as it relates to how to deal with deportations, and particularly mass deportations, and any attempt at expedited removals. Go to the chat here now. Mike Ferreira Sr. says, BS. George Ryder, I'm sick of hearing habeas corpus for every screwball, illegal alien gang member, old kid sniffer Joe and his idiot sidekick Kamala waved into the country. We got a huge marble eyesore to a man who suspended habeas corpus. Sits right there mucking up the National Mall. Pick a flavor and run with it. Well, yeah. So do you need to suspend habeas corpus to deal with removals? The Homeland Security, the Thuraissigiam case that we cited in this piece had to do with habeas corpus, whether the 1996 expedited removals were invoking or suspending habeas corpus. And the court said 7-2, no. When you're dealing with removals, that is not a question of habeas corpus. Habeas corpus has to do with indefinite detention. And so a right to challenge the accuser in a court of law. In the case of removals, habeas corpus does not apply. So you might not need to suspend habeas corpus to deal with illegal aliens. Cricket Ruiz says, deport. I agree. Let's see. Abdul Rashid Bangura. Good day, sir. Good day to you. Is there any processing of work permit for asylum seekers who are not in parole program as of now? It's a good question. I don't know the answer to that. But I do think that, legal immigration is still going on. People can still get green cards, et cetera. It's like, people want, I think the Trump administration wants to encourage legal immigration. I'm sorry, I don't know the answer to your specific question of the work permits for asylum seekers. Paul Harrison, round up and deport every illegal immigrant. I'm with you, Paul, and 56% of Americans, maybe more, are with you. They agree too. Debbie Cosby, all illegal criminals need to go. Pretty firm verdict from the chat here. And one more, Alan Lewis, send them home. Yeah, I think that that's what President Trump campaigned on. And so his attempts to, I think, use the laws of the land, including the Alien Enemy Act, to try to create a situation where mass deportation is possible. I think he's going to try. And maybe the courts aren't going to let him do it. Maybe the Supreme Court, even with a Republican appointed 6-3 majority, is not going to let Trump do that. And therefore, they're not going to let any president do that, which means that the illegal alien, and if they invoke it as a constitutional matter, then I think people are going to be pissed off, to be honest with you. They're going to be really pissed off that there's simply nothing they can do. They can vote for Trump twice to take care of this problem, and that it makes no difference. The Supreme Court's going to stand in the way of something I believe that Congress and the president have a right to do. And so we have one more chat here. Guy Johnson says, deport. Yep, I agree. So this is Robert Romano, Executive Director with Americans for Limited Government and Americans for Limited Government Foundation. Hit that subscribe button, ring the bell for notifications, and have a good day.